Thank you for the indulgence, Ash. You know, when we have work and then I even tried to come out early today because I saw yesterday there's one place that I passed on the way home, and for some reason I saw that the area was just having a lot of traffic. So I thought I beat it, but yeah, but I'm here. So just like yesterday, quick recap. We started with the pre-trial stages, and the main topic for the day was when we discussed about investigations, and particularly under investigations, we focused on identity, identification. So we spoke about the type of evidence that you find when evidence of identification is presented, that it can be direct, indirect, in times of circumstantial evidence. We discussed that this kind of evidence, both direct and circumstantial, will be treated with caution. And I said with direct evidence, although it may be an eyewitness who gives testimony, someone says they can't see the slides, but I saw fingers up. So can I take it that maybe this is one isolated case, or can you confirm with fingers up if you can see the slides? Okay, so maybe the person, let me see, it's Tolakele, maybe do like I had to do, go out and quickly come back in. Then maybe you will be able to see the slides, because everyone seems to be able to see the slides. Yes, just go out and come back in. So, Donald, why is your hand up? We're just starting with a recap.
It's just a hard hand, ma'am. Sorry.
Okay. Yes. So if a direct evidence comes from a testimony of, for example, an eyewitness, though they may say I witnessed or I saw the particular incident happening, we still apply caution when we deal with that kind of evidence. The same goes with also evidence uh, which is called circumstantial, like your fingerprints, handwriting. So all evidence, basically, caution must always be applied, because human error is it's something that is common, because people would say that, for instance, with circumstantial evidence, if it's fingerprints, the likelihood that there can be a mistake that has happened there, it's slim. Or if it's DNA, they would have you believe that, how do you challenge DNA, because they take a whole extensive process in the profiling of this DNA comparison. But the point is, these comparisons, this testing is done by human beings. And whenever human beings are involved, we know mistakes always happen. So you may not necessarily challenge the outcome of the testing, but you may have an issue to raise about the manner in which the samples were handled, and how the chain of custody was secured to ensure that there's no tampering, and. So that is why we say both circumstantial and direct evidence should be treated with caution. Then we moved on to say, you as the, or we moved to the identity parades, and we said the accused has a right at the parade to request to have their attorney present. The form that I told you gets completed by the officer who's in charge of the identity parade, who is not the investigating officer. it will indicate whether the accused was advised of this right to have their lawyer present and what did they choose. If you see on the form that the accused had elected to have their legal rep present and they were not given an opportunity to have their lawyer there, then it's an issue that you can also challenge, because we discussed also how the rights of the accused have to be protected, and we have to make sure that if the accused raises the request that they want to have their legal rep present at the ID parade, the police are not supposed to continue with that parade. They have to allow the lawyer to be there. Even if they had scheduled for witnesses to be there on that day, if the lawyer cannot be there on that specific day, they have to do this parade on another day when the lawyer will be able to be present. So we know that you are just there as an observer, you take notes, you don't interfere. I discussed under the cautionary rules some principles that came out of the case laws and the factors that have been laid out in the case of State versus Muthetwa. And we discussed at length what factors the court would be looking into when we are dealing with this evidence of identity. And I highlighted the main factors there, things like prior knowledge, whether they knew each other before or they had no prior knowledge, opportunity for observation, circumstances under which this observation was made will have to be thoroughly scrutinized in order to establish whether this witness was able to have an opportunity to make a clear observation, and that evidence which they are giving to the court can be relied upon. So description and factors like the description, we dealt about how the features of the accused are important, that they should be mentioned at least when the witness, after the incident, reports this matter to the police. We take it that the incident is still fresh in their mind and they can be able to recollect the most important aspects of how the assailants look like. So it's very important that you check that statement that they made to the police, you compare it to the testimony that they are giving in court, and where you see that there's discrepancies, you then have to address it, and obviously that will be done under cross-examination. So please don't be surprised, ladies and gentlemen, sometimes these witnesses, when there is a big discrepancies when they are testifying in court between their evidence in court and what's in their police statement, they would try and distance themselves from what is written on the statement. But you have to pin the witness down to that statement, because that statement was made under oath, just like the testimony they are giving in court under oath. And also you have to emphasize the fact that you are expected to have a better recollection of the events as it was fresh in your mind, compared to when you are now maybe months or even a year later or years later when you are coming to court, that you are coming up with such crucial information which was never mentioned to the police. So if there's a dispute concerning maybe how they what they normally do, they would say, I didn't say that, you know. So now that would call for you to enter into a trial within a trial, and then you have to now obviously call even at the court to have the police officer who has taken down that statement. Now, from experience, I can just quickly tell you that if there's a difference in the statement to the police and the testimony in court, you can likely expect that that officer, when they come to court, they will stick to what is contained in the police statement. So that will work against the witness if they are trying to deny that that is what they had told the police. But of course, you will have to cross-examine thoroughly and try and show that those inconsistencies are, something that the witness shouldn't have done, because even before they testify in court, remember, there is no witness who will take the stand without being given their police statement to refresh their memory. So you can even bring it to that point and say to the witness, you had an opportunity, even here at court today, before we start with this matter, that in the morning the docket was handed to you, so you can read your statement again to refresh your memory. But however, there is still these big differences in the testimony. So yeah, that's how you will deal with that. And then the court will make its ruling after you have done all the examination, and then the court will decide whether it accepts that police statement or it's not going to be admissible as evidence. And then you will proceed with the main trial. So I did say, even with a parade, the forms will tell you that the outcome was positive or it was negative. It will go into detail about how long even the witness took to look at the people who are at the parade and now make a pronouncement whether they are able to identify anyone or not. So please look out for those photos if you are able to get them where you were not present at the parade. You look at them very well and look for those things that I told you will be points of attack in terms of how the people would probably not even look anything alike, dressed differently and all that. So yeah, the build, the appearance and all the details of how this accused is no surprise that they've been pointed out, because maybe they're the odd one out, or they're the tallest of the bunch who was on the lineup, and then we moved to search and seizures, and we discussed there, ladies and gentlemen, evidence of items that have been seized by your peace officer in terms of Chapter 2 of the Criminal Procedure Act, following the provisions there and determining how these searches and seizure had to be done and what may lead to these searches and seizures being considered to have been done in an unlawful manner, and how to ensure that the proper procedures were followed to obtain such evidence. If there's a dispute with also the admissibility of these items regarding the manner of obtaining such evidence, whether it's a search that's been challenged or the seizure itself, we do that also by challenging it in a trial within a trial. And similarly, after evidence is laid there, then the court will make its ruling. Please don't be surprised sometimes also when you've done this trial within a trial, you may hear the presiding officer saying at the end, you are expecting them to say whether that evidence is admissible or it's not going to be admissible. Sometimes they don't. They may just tell you that maybe at that stage, they are considering the evidence to be provisionally admitted. And then you have to go back into the main trial. So what does that mean? It means that they will only make a final decision after all the evidence has been placed before them, and when they are giving their final judgment on the matter, then they will rule to say whether that evidence which was provisionally admitted is now finally admitted or it's found to be inadmissible. Unkgopotsi's hand is up.
Yes, evening, ma'am. Now, would that not hinder with the defense strategy in terms of whether to bring an application of Section 174 or rather have the defendant stand to answer?
No, remember when you are making that application for the discharge in terms of Section 174, you are not just focusing on the evidence presented in the trial within a trial. You have to look at the whole state case. So, for example, the state started by calling the complainant who testified about how she was robbed. And then there were there was also, after that witness, there was maybe an arresting officer who came to testify about the search and the seizure. Now, if you had issues about that, you went into a trial within a trial with that arresting officer, it's still under the state case. And then the court will make its ruling. And if it says, okay, at this point, I'm provisionally admitting that evidence of the search and seizure, then let's proceed into the main trial. Then maybe after that, the state still has maybe an eyewitness who comes also now to corroborate the testimony of the complainant regarding how they had witnessed the robbery. And then when they are done with all those witnesses, they now inform the court that the state case is closed. So you, as the defense lawyer, you have to now look into the section itself. What does it say? The test that has been set out in terms of case law, what is it that at that stage, remember, the state need not prove its case beyond reasonable doubt. But the only thing the court wants to see is whether the state has made out a prima facie case against the accused, which will call for the accused to now come and answer to the allegations leveled against them. So you now, as you are making that application for Section 174, you have to look at the entire state case in its totality. And your argument will be, from the evidence that is before the court, after those witnesses came and testified and they were cross-examined, you are of the view that the quality of the evidence before court is not sufficient for any reasonable court to can pronounce a conviction. There is no court that can find the accused guilty based on the evidence that is before court. And you will say what's wrong with the evidence that's presented. So even if the evidence is provisionally admitted, once the state case is closed, you now reassess their entire evidence that is on record, and then you can decide whether you want to try for a 174 or you now have to just allow the process to enter into the defense case. And even if you've done the defense case, you're still gonna have an opportunity to argue for a conviction, being the state, and you'd now be arguing for an acquittal as the defense. The only difference now, after the state case and the defense case have both been heard, the test is different now. It's now the state has to prove its case beyond reasonable doubt. So you may likely not get your discharge with that initial case where you had the court being of the view that it's not totally disregarding the evidence of the search and seizure, because if it's established on face value, prima facie case on face value, it appears that accused is linked to the commission of the crime. Therefore, they've been somehow placed at the scene of the crime by the evidence of the witnesses, linking them to have been part and parcel of the committing of the offense. That is sufficient for the court to refuse your application, because the only thing is you check, has the accused in any way been linked to the crime itself through identity, through, you know, a proper, maybe items that are actually connected to the offense, which were robbed, being found in the person of your client. And what is your defense? You have to check, what explanation does the accused have if they've been found with items that belong to the complainant? How did they end up with him or her? So you see, if that's the case, you are likely not to get a 174, because he will need to come and explain, why were you found with robbed item shortly after the incident has just happened? What is the likelihood that this thing just fell out of the sky and landed on your lap? You see, just think of it in simple terms like that. Then you will be able to clearly, and a lot of times, lawyers, they don't really get, you know, when they need to make that application for the 174, or to just leave it and proceed into, you know, the defense case and argue there for an acquittal, because at that stage where it's only the state case on record, the test is light, or rather more lenient, in terms of what the state has to prove. Just a mere mention that the accused was there, they're the one, I identify them as the one, and something belonging to me was found on them, then that's enough for the court to refuse the discharge. Because the court will want to hear, how do you explain now being found with items who've just been robbed? You see, and I see a lot of times, you know, lawyers get frustrated because they are believing so strongly that, no, I mean, there's nothing here. You have to always try and put your emotions out of, you know, the whole scene, even if you believe that maybe the witness that have testified, they've exaggerated or whatever. Yeah, you point them out if you saw that they are lying, they are exaggerating, they are just adapting their story as they are talking to just force to implicate the accused, but there's actually nothing. If that's the case, then you can try for a 174. But the best way to know when to make that application is to check, is there any way that these witnesses are linking the accused to the commission of the crime? Are they in any way placing the accused at the scene at the time of the incident? Is there anything found on the person of the accused that places them to have been possibly part of the crime? Then I think when all those answers are yes, 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 just forget. You're not going to get your 174. Rather just go and proceed with the case. I hope you understand clearly. So the court pronouncing that at this stage it's provisionally admitted, it doesn't stop you to ask for the discharge, but you have to weigh up the evidence, all the evidence in its entirety. That is what's presented by the state before you can make those arguments. And I see that sometimes people will be arguing endlessly, but read also, you know, the section and look up the cases that dealt with the test that the court should apply in order to determine whether there is a prima facie case or not. There's a case law to that that will assist you to try also and simplify for you to be able to know whether you should make that application or not. Okay.
Thank you, ma'am.
You're welcome. So I did say that, you know, we all have rights, and the manner that these accused are to be searched should be done in consideration of the constitutional rights of accused as human beings. So, but as much as you want to call for the preservation of the human rights, you have to consider that there's Section 36, which is limiting how those rights are to be exercised. And if indeed it is found that the search and seizure has happened in a way that is unlawful, then Section 35(5) of the Constitution is there to clearly say that kind of evidence, it's to be excluded because it's to the detriment of the administration of justice, and it will be found to have been unconstitutionally obtained and therefore unlawful. So it won't be admissible. Okay, Sindiswa, your hand is up. Sindisiwe.
Yes. Just sorry to want to take you just a step further. The thing is, you mentioned the Section 174, so I've been curious for some time. So let's say, for example, in a trial, it so appears that there have been a number of errors made by the prosecution. For example, the search and seizure, it's found that there was something faulty with the warrant. So everything that was searched and seized there is in question. The documentary evidence provided also, there's an issue in terms of authentication of those documents. And there's just a number of errors, for example, and a 174 discharge is granted. When the prosecution or the state in this regard then take the matter on or request for a possible appeal in the matter, meaning asking the court of Kuyu to actually decide, or that judge to decide whether they can possibly appeal if another court will find differently. My question is this: should they rely on, is it questions of law under 319, or is it a normal appeal?
No, it will be a question of law, because the Section 174 brings the matter to finality. And unless if there was issues maybe about the procedure that was followed in how the trial was conducted, then you could try for a review. But in that case that you are explaining, they can only challenge the appeal on points of law.
Okay.
And yeah, you do understand that once the accused, unless if then the higher court can come back and say the law was not properly applied, then that picture will change. But otherwise, the accused is a free person.
Yeah. So if the appeal is then, I mean, if the court of Q then decides, no, it's fine, go to another court and appeal it on questions of law, does it then go back to trial?
No, it goes to high court. It goes to high court. There's no appeal that happens in the lower court. All the appeals will start from the high court. And if you don't get joy in the high court, then you go up to Supreme Court of Appeal and sometimes maybe Constitutional Court. But because I mean, there's no way that another magistrate can overrule another magistrate. You need a judge to come up with a different decision to overrule a magistrate.
Okay. Thank you.
Okay. So, ladies and gentlemen, we also spoke about that reasonable suspicion. And this is a personal belief that the officer should hold about. So they are drawing their own personal, it's like a judgment, if you want to call it so, they're just looking at the accused and they're like, this one, I suspect that is involved. So it's subjective. And yes, they are empowered in terms of Section 20 for them to formulate that reasonable suspicion based on their subjective belief under the circumstances, of course, that they are faced with. But this also is open to a lot of abuse. And whether it's deliberate or not deliberate, but it happens that at times you can see that because there's no specific definition that has been put to say only, or maybe a few factors that say only if the circumstances are like this, then you are justified to formulate that belief. It's calling for a personal belief. So a personal belief will also be influenced by personal bias, your personal prejudice, your personal view in how you see people and life. So if you are faced with a case where an officer comes and they are raising that to say it because I had a reasonable suspicion that this person, I must ask to search them because I'm suspecting them that they may have something illegal on them, then it now calls for you to go deeper into how they formulated that reasonable suspicion. And hopefully you may be able to show that they were being unfair in their judgment, how they just maybe, like this example where, for instance, this comes up with people who would maybe just be sitting by a park and the police will say, at that park, we know that generally there's people who sell drugs and they smoke drugs. So on that particular day, I saw maybe a group of males who were standing in a group and they were looking suspicious. And I then formulated the belief that they could be involved in the sale of illicit drugs. That's when I decided to approach them and then asked to search them. And my search maybe has come up with some illegal substances found by this officer. So it's a difficult one. It looks simple, but it's very challenging when you have to show that you were influenced, by your personal bias and in the manner that you acted. In a way, you were harassing, the people that you saw, and because of course you'll get the instructions from your client. Sometimes they will tell you that nothing was found on me, but we were just standing there maybe as a group of men, and this officer just came, started to search us, and then told us to get inside the van. We were packed inside the van. We were going from one place to the next. We didn't even know where we are. The next thing, we found ourselves at the back of some police station, and we were all, taken to different offices. Some of the people we were arrested with, they were released, and some of us, we were not released. But later, we were not even informed of the reason why we were arrested. But later, we now came to court here, and we are told that we were in possession of drugs. We don't know anything about the drugs. We didn't even, have anything found on us. So yeah, the story will just come out from the instructions that you will receive. So that's how you will have to now go into that reasonable suspicion and reasonable belief. Because sometimes it's not always the case that the police are acting, you know, according to what they ought to do. And sometimes they do extend their power because they know that all I have to say is I had a reasonable suspicion. And that's where some elements of abuse will also come in. So you look out for that. We spoke about the legal privilege, that you are the ones who must preserve that legal privilege that is covering your client, and you don't compromise it. We spoke about searches that happen with a warrant, without a warrant, and we went into the search with a warrant and what must be in the warrant specifically to be strictly interpreted. So we ended up saying if it's not in the warrant, then the police, they cannot do what's not contained in the warrant. If they want to cover for other unforeseen eventualities, like them anticipating that they may find other illegal activities at the place where they are going to look for drugs, maybe that they will also maybe find guns which are illegal there. They need to include it that any other illegal items that may be found and seized at that premises will also be covered by that search warrant. So that one is clear. And we spoke about the role of private persons, the role of auditors during these searches. I think we exhausted that. And we moved on to the search that happens without a warrant. Here we come back to the subjective view of the police officer, who now formulates an opinion that they are justified to act without a search warrant, and they only have to say there was reasonable grounds for them to believe that if they did not act immediately, the item that they were looking for was possibly going to be destroyed or disposed of, or whoever they were trying to catch was going to run away. That's what Section 22 empowers them to do. Sindisiwe, I see your hand. Maybe it's an old hand. Do you have any question, any comments, Sindisiwe? Okay, we move to Elodie.
Sorry, it's an old hand.
Okay, Elodie. Unmute Elodie so we can hear you. Okay, maybe you will type in the comments. So yeah, that is the position with the searches that happen without a warrant. And further now, an extended authority is given to the police in terms of Section 27, which now grants a police official the power to use such force that they may deem necessary to overcome resistance against a search or an entry. And Section 27, subsection 2, also includes the fact that they may apply the no-knock principle, where they can even enter the premises without announcing themselves as the police, and also include breaking of a door or a window to gain entry into these premises. the matter of state versus Gumede. I hope you found some time to look at it. And I don't know, did anyone really have a chance to just browse through that case? And I would just like to hear whether you are in agreement with the court or you are not in agreement with the court, how it reached the decision, the reasoning of the court. Anybody? Where's Richard today? Is he not with us? I would have thought that he would have quickly went to read up on that case. Okay, so let me just briefly summarize what the reasons of the court were. The facts were that there was a robbery, as I told you, at a cash pay point, and it happened almost 2 months prior to the date of the arrest of Gumede. At this robbery, there was security security guards who came to bring the money to pay the pensioners and the recipients of the grants. So upon their arrival, they were met by the robbers, and there was a shootout that ensued between the security guards and the robbers. One of the security guards was shot, but it wasn't fatal. I think it was on the leg somewhere. So it was just an injury that they managed to survive. And however, the robbers did manage to get away with the money. Fast forward to the date of the arrest of Gumede. Police arrive at the residence of Gumede in the middle of the night. It was around midnight, actually. They did not knock. They did not announce themselves. They broke down the door, gained entry, found Gumede sleeping, I believe, with his wife in the bedroom, and then informed Gumede that they are there to place Gumede under arrest. And they conducted a search. They did not have a warrant. They found a firearm. It was, I think, under a pillow, somewhere, or under a mattress, but it was in the same bedroom where Gumede was. And they took Gumede into custody. Gumede was taken after that, shortly after midnight, to the police station. At the police station, he met the investigating officer who sat and interviewed Gumede, and that happened to be an Indian police officer. Gumede is a Zulu-speaking man. So the discussion between Gumede and the investigating officer came to a point where some admissions were made by Gumede according to the state. And Gumede took the investigating officer and other officers to the scene of the crime in those early hours of the night, just after midnight, maybe around 1, 2. They actually went to the scene of the robbery, where some pointing out was done by Gumede in terms of explaining who was standing where, when the shooting happened, where the money was taken, and all that. After all that pointing out was done, the police were led to the home of Gumede's father. who was living a bit, far from the scene of the robbery, but it was still not too far, but yeah, a bit distance. But they managed to reach that place the very same early hours of the morning. The police said they were taken to the home of Gumede's father because Gumede said he was going to show them where he was hiding the money. Got to the home of the father, met the father, walked around the property, looked around. However, nothing was found. And then they went back to the police station. Maybe now it's around 3 o'clock in the morning. And further confessions were made in detail by Gumede. So seeing that all this information is coming out of Gumede, they organized, the police arranged for a Zulu speaking officer of a rank of a captain to come and reduce the confession of Gumede down to writing, to ensure that there is not going to be a language barrier, because the Indian officer was not Zulu speaking. So they got a Zulu officer, and then they managed to take down the confession. It was written, fine. By the following morning now, around maybe say 7, all of what I told you had been done and wrapped up, complete. And then the matter went to trial. Trial Gumede now appears in court, and Gumede says in his defense that he was beaten up by the police who took that confession from him, from the trial court. It was the line that the defense lawyers were going with. And despite that information coming out at the initial trial, that court still convicted Gumede, because also, remember that firearm which was found, it had been tested, taken for ballistics. It turned out to be a real firearm, which when they went to the scene of the crime, the police, they had found some spent cartridges at the scene, and some of those spent cartridges were linked to that firearm, which would show that the firearm which was found with Gumede was actually used during the robbery. That's another, strong evidence that they had. But now at the trial, Gumede, despite all this, he's now saying the police beat him up, and that's why he made that confession. And then the police were questioned, okay, why didn't you obtain a warrant? The police said, we received a tip-off that Gumede was actually planning to flee the area where he was living, and it was actually in KZN. And he meant to come in and hide out in Gauteng, just to lay low, so that, because maybe somehow he was aware that the police were looking into him. So the police then thought that, to wait and start looking for warrants with this information that we got in our hands, that Gumede is definitely the one of the robbers, then we will be missing a great opportunity to secure and arrest after almost 2 months that this matter had been lying open without any movement in that investigation, because all they had was a scene of a crime, people who did some shooting, the robbers did some shooting, and they managed to get away. No one could be identified by the witnesses. So this was a great breakthrough in the state case when they finally got that tip off to say that Gumede was actually one of the robbers. And they saw that wasting time, to get a warrant would then lead to them missing a great opportunity to arrest Gumede. This information was given to the police at least 2 days, and they only went to Gumede's place after the expiry of the 2 days. So that was the contentious issue, to say, didn't they have sufficient time to obtain a warrant in that 2 days? And the police said, no, there was too much at stake. And we had reasonable grounds to believe that they would definitely flee. And we had, reasonable suspicions that they are the ones, based on the information that they were given, that they are the robbers. So we had to act and pounce before they could escape. The Kotaco convicted Gumede, sentenced for the robbery and the firearm that was found to be unlicensed, and the ammunition as well. Did Gumede not go for appeal? Yes. Matter went to the High Court, and the High Court did not set aside the conviction of Gumede. It actually confirmed the judgment and the sentence of the conviction and the sentence of the Kotaco. Gumede did not rest, took it further to the Supreme Court of Appeal. There's a full bench of judges who now deliberated on this matter. So the most points that the judges in the Supreme Court were just wanting to be, fully addressed with them was, what is it that made the police not to use that 2 days to obtain the warrant? 1. 2, the court reasoned that it was bothered by the speed of how that entire case was wrapped up. From that midnight, when the police broke into Gumede's house, finding a firearm that's linked to the robbery, taking them to the station, confessions, going to the scene of the robbery, pointing out, ending up at the home of the father and coming back to the station, even changing officers in that, few hours to ensure that they get a Zulu speaking officer who's taking down the confession. So the court was bothered by the speed of wrapping up the entire case, that the court had concerns that this was a case that was a cold case actually for about 2 months. There were no leads, there was nothing ever since that robbery happened until this fateful day when they just break into this house in less than 12 hours. The entire case was fully investigated and wrapped up, ready to be presented for trial. So to the court, then it went into the reason, Gumede, why did you take the police to your father's house? Because the police, the state was going on that no, we didn't even know Gumede's father's house. He's the one who led us there because he said the money is there. And when that issue was canvassed, the response from Gumede was that the way I said those police beat me up that day. In fact, I saw that on that day, I was surely going to die. The manner that I was being beaten up and the assault was so severe, I saw my life flashing before my eyes. And the only thing that came to my mind under that situation, in that moment was my poor father. Oh, I wouldn't even have an opportunity to say goodbye. So when they said to me, look, take us there, let's go there, let's go there, they are the ones who took me to the scene of the crime. I didn't know the scene of the crime. From there, they said, okay, let's go, because they were beating me throughout. And at some point, I realized that, for this beating to stop, I just need to start saying, okay, fine, I will talk. Fine, I agree. And then if they said, let's go to the scene, at the scene, I stood there and I started saying, okay, I was standing here, I was standing there, that one was standing there, just for them to stop beating me. And before we could go back to the police station, I made a request to them that, please, let's go to my father's house. My intention was not to show them any money. That's why there was no money found there. I just wanted to see my beloved father once more before I was killed. So when the judges heard that, then they were like, okay, surely this is bothering heavily on the minds of the court, that it's not normal, with the normal running of investigations, that you will get, firearms that are related to some robbery quickly. Within 2 hours, you have a confession. Within 3 hours, you have pointing out, you've changed officers to secure language barriers, and within 6 hours, you are entirely done with the entire case. So for those reasons, the judges dismissed that conviction and they set aside, the entire sentence was set aside. Gumede was released as a free man by the Supreme Court of Appeal. Shocking? Somebody says, I believe Gumede.
Yes, it's me.
Yes. Jacqueline?
Yes, can you hear me?
Yes.
Yes, I said I believe Gumede. I think it's very possible with how police work and very, very shady things that go on there. So yeah, I believe him.
Okay. Is it non-tobacco?
Thank you. Oh, hello. Sorry. Yes, it is. I think I'm very sorry that I did not get to the case, and what I'm asking really pertains to what happened, to the facts of the case. What I want to understand is, apart from the firearm, was there like any other evidence that could have possibly led to Gumede, and even how he was pointing out at the scene that this person was there and that person was there? Was there any other evidence apart from the ballistic report that pointed to him? Because
Yes.
I do think that. Oh, okay. Because I think from I don't believe Gumede. I think that he was able to have a comeback and be able to sort of get away with a lot of things because the police failed to do their due diligence and essentially also just follow procedure. But
Mm.
I don't at all believe what he said. It's all just too convenient. And yeah, so I don't believe him at all.
To be honest with you, I was shocked also when I read the reasons of the SCA, the judge's reasoning, you know. I didn't expect that, like, wow. I was left with wow on my face. So the police said they got a tip off, which means at some point, Gumede slipped up and spoke to somebody who then told the police that they were involved. I don't know whether that person was called. I don't recall whether that informant was actually called. Maybe they were in the trial court. I'm not sure. You can read up, but most likely they might have called that informant who led the police to Gumede. Number two, it was those spent is it what cartridges or what, those casings, yeah, they were actually linked to what was found at the scene. So that was not the only evidence that they had, you see. So there was something else on my mind that I wanted to remember about that case. Yeah, but yeah. So yeah, they didn't just solely rely on the firearm. No, they didn't. They had more than that. And remember also the officer who was shot but didn't die, maybe that one also testified. Okay. Lipeta.
Good evening, colleagues. My question is in relation to the firearm, because the firearm places Gumede on the scene. So I'm trying to understand why did, yes, we can understand that maybe procedurally things were not done, but
Just
it
keep,
does not.
sorry.
Yes, but
Continue.
yes, but the fact does not dispute the fact that Gumede was there on the scene, because the gun that was found, I'm sure Gumede did not say that was his gun.
Remember that. Okay, sorry. I keep thinking you are done. Sorry.
Oh, sorry. Okay, yes, but I wanted to raise the fact that Gumede does not say that the gun is not his. The gun is placed was on the scene, which also places Gumede on the scene. Yes, we can. The other factors, to me, I feel that they are not that much relevant, as much as it's not the critical part of the case, as much as they are, I can call them mitigating factors or something that, not mitigating factors, I'll call them as cosmetics, because they don't actually relate to the core of the case. So I don't know, I just want a brief understanding that why the matter of the gun was totally ignored. Thank you.
I'm just thinking that the court there was looking at the manner in which that evidence was obtained to ensure that there was lawful process followed in obtaining that evidence from the firearm being found, where this search happened without a warrant. The court was not satisfied that they did this without a warrant. The court said 2 days was sufficient for them to get a warrant. So the fact that this was a real firearm, which was actually even linked to the have been used at the robbery. Now, even if that is really the truth, the manner in which that firearm was seized. You see, because the police came there without a warrant, and the court said they were not justified to do so without a warrant because 2 days was sufficient time for them to get a warrant. So even if what they found was legit, if you want to call it that, in terms of linking it to the crime, it cannot be admissible because the manner of searching Gumede's house was unlawful. There were not reasonable. There were no reasonable grounds for them to waste the 2 days. They couldn't give an explanation why they couldn't use the 2 days to get a warrant.
Okay,
To close
sorry,
that gap.
can I just do a follow-up just on that question?
Mm.
Is there a time limit that is placed that you must get a search warrant within a specific time, if I may ask?
No, there's no time. There's no time limits, but the fact is the police are the ones who brought it before the court to bring it up that they received that information 2 days prior to going to Gumede's house. Now questions will now come up. Then after you got that information, why didn't you secure a warrant? Because you knew from your informant that Gumede was involved in that robbery. So you were likely to find something or, yeah, definitely catch the robber when you go to Gumede's house. You see, because that information was considered by the police that they only went there after they had received that information 2 days prior. So they only went there on the 3rd day. So they left that gap to the judges. Then they wanted to know, why didn't you use that? Because getting a warrant doesn't take that long. That was the reasoning of the judges. Okay. I'm not saying I agree or disagree. I'm just telling you how the courts were viewing the whole thing. Okay. Who's next? Agnes.
Good evening, everyone.
Yes.
I only read the SCA judgment, and between paragraph 35 and 41, they mentioned that the Govender and Bata, there are times they were not agreeing how much time they used to interrogate Gumede. Some Govender was saying 45, and Bata was saying 1 hour to 1 hour 15 minutes. They raised it as a discrepancy, and that when they were reading Gumede his right, they didn't tell him that he mustn't do self-incriminating evidence. They just told him that he has the right to remain silent. And the other fact that the judge raised was that they used force on Gumede in order for them to make their case zealous. That's why they came to that decision that they made.
That case is very interesting. I'm glad that you've at least read part of it. So that, I mean, this shows, I think, everyone how it's important, because there's nothing else that has come out of our courts to do away with that decision of the Supreme Court of Appeal. When it comes to searches and seizure, this still stands as the authority. So it is very important that we all read that case very well and fully understand how the courts apply their mind when they are faced with such kind of evidence. So maybe it may be helpful to you and also make you to better understand how the judges, they were really just picking at every a issue that they were not letting anything slide. They went in, they went deep on that case. So it's a long case to read, but it's interesting. So yeah, I see Richard has joined us. Welcome.
I'm here.
Richard.
Hi, ma'am. I'm here the whole evening. I've been listening.
I've been calling you because I thought you would jump and say, yes, Elsie, I read it, you know.
Yeah, I just want to add the following. If you look at and we've touched on the Constitution when in our first in the Bill of Rights, and it's not only about Section 35 of the Constitution with the rights of the accused or the arrested person. But you should take it a step further. Section 14 of the Constitution speaks about the privacy of a person. And it outlines that everyone has the right to privacy, irrespective of who you are. And that right includes your right not to be, your home to be searched, you to be searched, your property, your possessions to be seized. And if you could take it further, and I would agree with the SCA on this matter, because the manner you obtain evidence, and it's in Section 35 of the Constitution that says any evidence that you obtain unlawfully will be inadmissible. Yes. And if you take it further, if you go look at, if you combine this with the law of evidence, it's the manner in which you collect your evidence. It should not be detrimental to the administration of justice.
Section 35, subsection 5. Yes.
Yeah, yes. But you should look at the admission of unconstitutional obtained evidence, and that will be detrimental to the administration of justice. I just want to add that. And I've been here the whole evening.
Okay, welcome. Yeah, no, to me, really, this case, it was mind-blowing, like, boom, when I got it, because whenever I had, this kind of cases, I would just find something, but it wouldn't deal with all the aspects, like, a search without a warrant, a pointing out, a seizure, it was like all encompassing. So that's why I was so like really happy that that case had dealt with all the aspects. Yeah, so yeah, let's see who's next. Is it Wheaty? Wheaty?
Good evening, Elsie. Can you hear me?
Yes, we can.
Richard just alluded to what I wanted to mention in terms of the Constitution, because I can see that in this statute, it says a peace officer who arrests the suspect may search the person arrested and seize any article referred in terms of Section 20 of the CPA, right? Which is in possession or under control of the arrested person. So then my question is, why do we have this provision if the judges could not look at it as, an exception of some sort, or rather it renders this provision invalid, because then Section 35 of the Constitution says that any article that is seized unlawfully, then the evidence will not be admissible. Because then we know that the Constitution is the supreme law of the land. So I feel that this search without a warrant should actually be invalid.
It cannot be allowed. Then a lot of criminals will get away with crime, literally.
Yes, but then Gumede just got away scot-free.
But Gumede doesn't say all, the cases. The focus was to ensure that even if you found you know, whatever items connected to the crime, the process of obtaining, the manner that you get that evidence. I think that is what the court was focused on, to try and balance the rights. Like Richard said, we have to ensure that people are not harassed and abused. Like now, imagine where you are and just kicks your door open, and they just, for no good reason, kicks your door open and finds you. Maybe you are even, you know, naked, and for no good reason, because they can use that section to say. So if the police are to act, they need to act with care and caution, knowing that they will have to satisfy the court that they were justified in breaking down people's doors and windows without even announcing who they are. Because even you could shoot them, you know, if you had a gun, you could think it's an intruder, because they don't even announce who they are. They just pounce, boom. So if the court allows, as the law is empowering them to do so, but the process, the manner, let's just focus there. We still need to make sure that people's rights are not trampled upon in them doing what they are doing. I hope that answers you, Hwiti. And I'm
Alright.
not saying, you know, police mustn't do their business, but with care and caution and
Okay.
consideration for people's rights.
Alright.
Kwanele?
I'm happy to have a mic today. Yesterday, I only relied on text because someone felt it was great to mute me.
Oh, shame.
But I'm not
That is
making a
not me.
case.
No. It's
No,
not
it
me.
wasn't you.
No.
No,
Sometimes, maybe if you get that, just go out and then come back in, please. Because what I do, I just put the slides on and I just keep going. I don't touch the even if they say they give me some controls, the only thing that I press is to stop the session. That's all. So if
Yeah.
maybe that happens again, just go out, come back in.
No, it's great, ma'am. I'm not complaining, and I think my colleagues have been with me for quite a number of weeks, and they know my wit.
Okay.
But I'm just looking at this case, and I do not think there's a point. If I put myself in Gumeda's feet, I would have said that the gun. I would have never not said that the gun was planted, because whoever alleges a fact must prove it. That's our law, right? So if you say that there was a firearm that is linked to a crime that was committed, then you must prove that that firearm belongs to me, right? If you find fingerprints on that firearm, then you must prove that you did not place my hand on that gun so that you can further your case, you know. So I'm looking at this and I'm just thinking, the judges might have been thinking in that direction, that why is the prosecution failing to prove, one, that the gun belongs to Gumede, and that's the first point. The second point, why can they not place Gumede in the scene? So everything else that follows after that, the fact that there was a pointing out, as a good lawyer, a defense lawyer, I would have been, yeah, the pointing out must have been there, because you know that whoever alleges a fact must prove it. So to prove that my client, Gumede, is actually the owner, and to place him in the scene of crime, you must have, through your special CIA training interrogation techniques, did something that puts him in a place where, you know, it proves the fact that you're trying to do. So I do not believe Gumede, but I think the wheels of justice turned in his favor, because again, I'll remember one of my learned colleagues yesterday where the police said that, you know, we have a couple of guys that are in custody who are linked to similar crimes. If you go and say something, then we can link them to this and then everything will be fine. So I
Shady
think
operations. Shady operations.
exactly, you know, so I wouldn't judge the judges for the decision that they came across, because if you apply your mind to this case thoroughly and you're not taking sides, which is something that I've been trying to do in my studying of this, and I realized that because we have a particular principle that says whoever alleges must prove, I will do everything that I must do as a cop to try and prove my allegation. But then again, as a defense attorney, I'll try to attack everything that you say that proves that allegation. And as a judge, I'd say that, well, I have reasonable doubt to believe that what you are saying to me doesn't hold water. So with reasonable doubt, I would say that as a defense lawyer, I would ask, if I say my client actually was not there, what do you have to show that he was there? You know, and I don't think that was found in the prosecution's side, and therefore Gumede walked scot-free, whether guilty or not guilty. But our law says not guilty until proven guilty. So we might be working with someone that's gonna rob us one day.
Shame. Yeah, ne? Okay, thank you so much, Malikole. I think you are the last one because Elodie forgot to lower her hand long time. Are you sleeping on us, Malikole?
Hi, ma'am. No. Yeah, I'm just struggling with reception. Not a problem. But by the way, what Mr. Charlie, I think. Sorry about that. I've captured what I wanted to indicate. Just one comment on a similar case. I think it's a couple of years ago, the guys who robbed, it's a cash in transit, they robbed a depot or SBV depot somewhere in KZN. Similarly, they were caught with the money, millions in their ceiling, but the court eventually let them go. They found them not guilty because the evidence was unconstitutionally obtained, that led them to the police to find the money. So that's just what I wanted to comment on.
Okay. Yeah, thank you so much, Malikole. Yeah, these are very, very interesting cases. There's more that you can meet out there. I see someone is sharing another one here. Mukushukelo. Okay, maybe they can give us a full citation. It's good for us to, keep reading up on these cases. But the point of departure is really the judges. They are there as the custodians of our law, and they don't miss an opportunity if they are called upon to dismantle, the legislation and, and come out with this kind of, cases that are groundbreaking. So it's good to know that we have judges who really scratch their heads when they are faced with cases, whether you agree with them or not. But at least we see that they really scratched their heads before they came up. Malikole, you are on. Please mute. We can hear Mama talking at the back. Malikole.
Sure. Yes. Sorry. Sorry.
Yeah. So yeah, the point I was making is good to have these judges. So yeah, Janus, I think we are closing with you. We really have to move and see what we can do further.
Good evening, ma'am. Trust things are going well. I've just noticed it's 7 o'clock, so I'm not sure what time you want to schedule a comfort break for tonight.
We can take it now and maybe in 10 minutes, 7:12. Let's do that, and then we will continue with what we can do for this evening. I think we've been having an overload of information. So that is, I feel like I was running fast, so that is why I've taken time to really do a full recap. And as you can see, there's lots of issues coming up. So I'm not regretting that I did take up quite a bit of time today to do that recap. And yeah, we meet up in 10 minutes. So 7:13.
Apologies, ma'am. Would it be possible for us to make it a 15-minute break, just for case and in case?
Okay, 7:15. Is it fine?
7:15 is perfect. Thank you very much, ma'am.
The time or the year?
No, we are coming back 7:15. You are now eating into the time. 7:15. Thank you. Bye. Hello, hello, hello.
Good.
Hey, good day,
Good evening,
ma'am.
ma'am. We are back with you.
Hi, Elsie.
Okay, all right.
Hi, ma'am. We are back.
Okay. I see. Elodie, maybe you forgot your hand up. Please lower it if you don't have anything to say so we can move on. Yeah, so I think we stopped here yesterday where I was saying that when the police conduct these illegal searches, such evidence cannot obviously be admissible if presented before the court, and where the police official who has approached to the court to obtain a search warrant, the judicial officer who gives a search warrant based on falsified information, such a police official can also be liable to be convicted for falsifying information which has led to the warrant being granted based on wrongful information. The person who also gives this false information can also be criminally charged as well under circumstances where the search warrant is issued and executed based on such false information. And there the charge is perjury. And the victim of this unlawful searches can also approach the court under the Criminal Procedure Act to seek compensation, which is provided for in terms of Section 300, that they would want an award of compensation due to the prejudice that they would have suffered out of the police having acted out on that wrongful information. Forfeiture and disposal of seized articles is the next topic. Now it happens under Section 3236 of the Criminal Procedure, where it is laid out the procedure that is going to be followed to dispose the forfeited items and how they need to be, if they are to be disposed of, the procedure is set out in those sections. If they are to be forfeited to the state, the procedure is also set out there. Normally, if the items were kept in the police custody and they are required to be presented as evidence in court, they are handed over to the clerk of the court or the registrars for the safe custody. So if the object has been handed in as in court as an exhibit, the presiding officer must make an order as to how the item should be disposed of. A seized article can be returned to its owner if not needed, or it can be handed to the court if no person may lay a lawful claim to that item. The police, they don't know who's the person who lawfully possessed this item. The article is to be forfeited to the state. Section 35(1) empowers the court, after it has convicted the accused, to forfeit certain objects that were used in the commission of a particular crime. Now, there's different laws or legislations that we have in our country that deals with forfeiture, depending on the specific item that is to be forfeited. You have your Liquor Act, Drug Trafficking Act, you have your Counterfeit Goods Act, just to name a few. So in these pieces of legislation, you will clearly be given specific direction on how, once the matter has now been dealt with in the courts, how those items are to be either disposed or to be forfeited to the state where necessary. So that is all, ladies and gentlemen, on the topic of searches and seizures and how these items get forfeited. To introduce a new slide. I'm gonna be really strict with time today. We have to adjourn a bit early today. I really struggled today. I was just feeling overwhelmed, even at work. So let's see how much. It's a lot of slides that are on here, but we've covered most of this. So I'll just move to the relevant part and start from here. Okay, so I think this might possibly be the last topic that we do for this evening, and then we'll take over again tomorrow. Now, there's different methods that are available in court once the accused is in court to secure their attendance. The most popular one is for the accused to be placed under arrest or to be under police custody. Please note, arrest, due to its invasive nature, in all respects, it is not encouraged. I don't know whether the police are told about this, because it seems like once there's a report, first thing is to arrest, take you into custody. So the point I'm making here is that arrest must be used as a last resort by the police. As we have seen, that a lot can go wrong in immediately once a person is taken into police custody, and more evidence of this comes out of all these many cases that are being made out against the state for unlawful arrest and unlawful detention. So yes, arrest is one of the methods, but it must be a last resort. So if it's possible for the police to just give you a warning that, look, just come to the police station tomorrow morning by 8 o'clock, and by 8:30 we can walk together to the court. The police should do that. They mustn't take into custody each and every person who is reported to have been alleged to have committed a crime. I mean, depending obviously on, we're talking here about less serious offenses. An arrest, it should be authorized by a warrant, but it can, as we know, happen without a warrant. You'll check the provisions of Section 39. But I think what we know is, and what is common in at least, if not 85 to 90% of the cases, the police, they do the arrests without a warrant. So arrests can also happen in terms of the Immigration Act. This is when we are dealing with foreign nationals, ladies and gentlemen. And the practice in the courts is, okay, the law itself in terms of immigration, we know that they are supposed to be answerable to immigration officers when they are asked to produce their documentation to show how they are in the country, as required by the Immigration Act, that it is their responsibility to show that they are legally in the country. But in most instances, we find that because of the high number of foreign nationals that we have in our country, you find that the criminal courts are being used also to process foreign nationals, like sort of to use the criminal courts as immigration courts to address issues of immigration. Now, it's in most cases that I'm aware of, they ordinarily come through to the court, the criminal courts, with a criminal charge also being made out against them. And I'll tell you, in most instances, you find that they don't really have a case that they can go on. I mean, the criminal case, in most instances, those cases fall apart. They don't stand. Or maybe the complainants don't go on with them, or they don't have sufficient evidence to prosecute the criminal cases. And then they will now proceed with the section 49, I think, of the criminal, I think it's the Immigration Act section 49, which is now going to address their legality in the country. There were some courts that I was aware that immediately when the criminal matter, Richard, I've noted you, when the criminal matter falls away, say for instance, this person was charged with malicious damage to property, and for some reason they're not going to proceed with that criminal case, maybe lack of evidence, or they just can't, pin down this accused to that case, and they're left only with the fact that this person is suspected to be illegally in the country. There were some courts who would release, but I've also gathered that now the practice has changed. They are actually proceeding on those section 49 charges alone in the criminal courts. Richard, what did you want to say before I go on with this case that's on the screen?
Yeah, thanks, ma'am. You were referring to about the arrest is the most vicious forms of bringing someone to court. Now, because it infringes on a lot of rights within your constitutional right. But, and I'm speaking of experience, I've been in law enforcement in my previous life for some years.
Okay.
And
that's good. I love, meeting you. I actually had one colleague who was a constable for 8 years who joined our office. So I learned a lot from him as well.
Yeah,
with the internal operations at SAPS.
Yeah, but I left SAPS about 21 years ago. So.
Okay.
And what you see today is do not arrest, and in some of the matters that I deal with is you ask the accused and his attorney to meet you at the police station. So you rock up there, you process the person, so he appears in court. Based on arrangement between the client and the attorney as well as the policeman. So now
Yeah.
you go to court, and I don't want to go into the sections of the Criminal Procedure Act, of the schedule of the offences.
Yeah.
Now you get to court, and what happens then is the prosecutor says, because it's a Schedule 5 or Schedule 6
Yeah,
offence,
no. You can't.
we are going to oppose bail, and the accused must now say why he wants to go out on bail. But the
Yeah.
prosecutor said, make arrangements with the accused to come and meet you. And it was shown in the matter of Bosasa, the COO of Bosasa, the guy that cannot stand trial now because he's sick. And even in the
Angelo
asbestos,
Agrizzi.
yes, even in the asbestos matter, people came to court on the prosecutor said, do not arrest, bring the people in. And when they arrive at court, now they say, you must tell the court now why you should go out on bail in terms of Section 60 or 61 of the Criminal Procedure Act. And we're postponing this matter for 7 days.
Yeah.
So
I'm
it is
gonna-
not on the fault of the police, but on the
Oh.
prosecution,
Okay.
because the accused must now satisfy the court why he should be released on bail because of the schedule of the offense. So what's the difference of arresting the guy? The guy comes to Sandton Police Station or to Mpumalanga Police Station, but now we're going to keep you in custody for 3 days. You must satisfy the court while you want to go out on bail. So it's not the police that opposes bail or decides on bail. It is the prosecution, the NPA.
Who are making you look like bad guys. Okay. No, it's good to know at least. Because on this side of the fence, it looked like the police are just picking up everyone and throwing them into custody, you know. So I now understand. Thanks for shedding light into that.
Thanks.
So we will get to the part where we're gonna talk about that 7-day rule thing. Yeah. So I think also there it will show on the part of the prosecutors now that they seem to also lack understanding of how that rule that they call the 7 days rule, it's meant to be interpreted. They are misinterpreting it. So we'll get there. So what I wanted to say here on this slide about the immigration issue, there's a case that came before the Constitutional Court. It was brought by the Lawyers for Human Rights against the Minister of Home Affairs. The bone of contention was the provisions of Section 34, subsection 1 of the Immigration Act, because they were saying those provisions were inconsistent with the Constitution. So they were saying they're not in line with the provisions of our Constitution concerning whether a court could issue a warrant of detention and authorize a deportation of illegal immigrants, because that's what those Section 34 is dealing with. So when the matter came out of the Constitutional Court, the conclusion was that Section 34, 1B and D. So I think you can see that there's an A and a C. Only ones that were inconsistent with the Constitution is B and D. But A and C was fine. So when that court order came out, there was, I think somebody didn't read and then started spreading the information without all the information that was necessary to be assimilated to the colleagues on the bench. The information was spread to the effect that now all the provisions of Section 34 have been found to be inconsistent with the Constitution. Therefore, a court would not be authorized to make a warrant of detention and authorize a deportation of illegal immigrants. So that case, it actually shook the benches. Like the magistrates were fighting between themselves, and there's those who went ahead and created a standard form, which was a release, sort of like a release warrant. Whenever they came across an illegal immigrant, no questions asked, they just sign, stamp, order the immediate release of that illegal immigrant. So those who had actually a different view to how that case was supposed to be interpreted started now to raise issue that no. It cannot be that we just let people go when we know that they are illegally in the country. So this called for intervention because the presiding officers were in disagreement. The state law advisor was asked to read into this case and give a clear directive or guideline on how they should interpret that case. And this is the outcome. The effect of this case is that the detainee is the illegal immigrant, suspected illegal immigrant, right? Because everyone is innocent until proven guilty in South Africa, right? So the detainee must now be brought before court within 48 hours, just like your ordinary accused. The rules are that the rights of an accused basically apply similarly to an illegal foreigner or suspected illegal foreigner. I don't know, but yeah, the foreign national who's suspected to be illegally in the country. 2, now the court must hold an inquiry regarding their further detention. When they are brought to court, they must be given evidence to show that they are illegally in the country, right? And if it is found that indeed they have failed to show, because the responsibility rests on the foreign national to show that they are legally in the country. If they have failed to prove their legality in the country, then a warrant of detention will be made by the court. And it will be specified in the warrant for how long they must be kept in detention. And if that period that has been stated, I believe it shouldn't exceed 30 days, that they will be kept at a detention center. If the immigration authorities, they foresee challenges that they will not be able to meet the deadline set by the court to deport this person back to their country of origin, they must ensure that they approach the court timeously to request an extension of time. And the extension will not just be willy-nilly granted. They have to give reasons to say why are they not taking that person back to their country of origin. The aim is to avoid those lengthy periods of time where people would be sitting, lounging there in the detention centers, as it has been happening in the past. So therefore, if the state has serious challenges to get this person deported, this detainee will be also advised that they can apply for bail and they can be released on bail while the Home Affairs is sorting themselves out. Hopefully they will find them. Yeah. So basically here you need a court order to order the detention, and it must be specified for how long. And if the time is to be exceeded, they can't just be kept there without being brought back to the court. They have to be brought back and an explanation given to the court why they haven't been deported. And if extension is needed, reasons must be given why and how long they will need. And then further detention will be ordered. And hopefully then they will be able to be deported timelessly without being there for extensively long periods of time. So during their first appearance, they are treated like an ordinary accused, and all the rights of an accused person apply to them. So they may remain silent, they may what, they may what, they may what, they may what. They may have legal representation. All those rights applies to them. This is an ordinary criminal court, but it wears a cap of an immigration court, because here in South Africa, we don't have dedicated criminal courts. So a normal criminal an ordinary magistrate who presides in the criminal court will be the one who sits in that court and presides over this issue of the immigrant who, so it's like an immigration court, given a status of an immigration court. That is that about foreign nationals. Second method to secure the attendance is through summons. So if accused is not in custody or will not be arrested, they can be served with summons by the police in terms of Section 329 of the Criminal Procedure Act. The service on this person is by handing over of a copy of the summons at the place of residence, at their place of work, at their business where they operate, to a person who is over 16 years. And this summons must be served 16 days prior to the date of the trial. And a return of service will be completed by the police when they do the service to say they have effected a service on this day to this person, and it will be given to the court, handed in court to show that there was proper service effected, and such would constitute prima facie proof of service. So that's one way we were saying they could avoid the arrests. But yeah, as our colleague has already told us, the challenges with making these agreements, then people don't stick to their word, they don't show up. But the provisions are there in terms of Section 329 that they can do that. They don't have to place people under arrest. Written notice to appear is another one in terms of Section 56 of the CPA, and it says that a notice may be prepared by a peace officer. This notice, ladies and gentlemen, is commonly used to be served on children, or rather minors who would be appearing with a legal guardian, where a child is in conflict with the law. So they will serve that notice on the child and the legal guardian to inform them that they need to appear in court on a particular day at a particular time. And also with your release on warning, it can happen like I think that's what Richard was talking about. Section 72 of the Criminal Procedure Act says the police or the court, when dealing with maybe an example of a child offender, they can release them to be under the care of their legal guardian, and that legal guardian will be warned that they need to ensure that they bring the child to court. Failure to appear and the consequences will be faced by the legal guardian, because we take it that the child is their responsibility. Makasani?
Yes, ma'am. I wanted to say we have started with this part the first day we started. I don't know if ma'am is aware of that.
No, we haven't dealt with this.
No, really, I'm looking at my notes here, ma'am. We started with.
To secure the attendance, we haven't.
Yes, ma'am. Yes, definitely.
I
I
haven't
don't
talked
know
about
if my
this.
fellow colleagues are aware of that, but yeah.
How come? Are you saying I'm on the wrong slides? I haven't talked
Not
to
so-
you about. I haven't talked to you about this. No, Makasangi, please go back to your notes and check properly. I haven't talked to you about arrest. I haven't talked to you about someone's. I haven't.
Makasani was in another class, not this one.
Yeah, no, you haven't, ma'am. You
No,
haven't.
I know I'm tired, but yeah.
Nah,
We are
maybe
awake, ma'am.
I think you're talking about
It's
your
my
law school,
notes when I
your
was studying on
university
my
days.
phone.
Ma'am,
Yes.
I think maybe Makasani did a pre-study before the class under resources
Oh, yes.
for last year.
No,
There are
definitely.
two
I think
videos
that
that
is
are
it,
there
because
for
like,
the 4
yes.
ways to secure an appearance attendance. So he's now thinking, wait, is this a repeat? No, he's thinking about those 2 videos. Different lecture.
Or his brain is just on overdrive. I think.
No, it's a different lecture, but on the same topic.
But that's
Yeah,
why I'm
maybe you
saying.
can
That's
share
why I'm
that notes with us, Elsie.
Yeah,
It's
you
under
guys-
resources. Sharp.
Ma'am, Makasang is ready for exams. All the best
Yes.
and good luck.
Wow, guys. No, guys, please. Makosange, we haven't talked about this. I mean, I know I've been overloading you with information, but I know for a fact this is the first time we talk about this. So please just maybe go back and yeah, relook at it. You will see we are talking about this for the first time. Okay,
My
so
apologies, ma'am. It's
okay.
my
It's okay.
mistake. I think
We
I've done
understand.
this before, so yeah.
Okay,
I thought
so
all
we are
of us.
closing. Okay, Makasanke, we are closing the methods to secure them to come to court. Now we are changing gears. We are going to start talking about the methods of securing the release of the accused. Please don't confuse them, ne? Because just now you said we've been talking about methods. Yes, so now we are talking of methods of release. Because what we were sharing just now is methods to bring them to come before the court. Okay, so the first method, it's gonna be quite a long discussion that we're gonna do here. I know it will get a bit hot maybe also, but let's touch on it a little bit, maybe for a few minutes, and then we can, I think, adjourn for the night and come back fresh tomorrow, deal with this nicely. So it's bail applications. Bail applications is the first way we try to get the accused to be released. And there is a purpose with a bail application. The purpose is to secure the attendance of the accused in court. So when we ask either the police or the prosecutor or the court itself that please take confidence and release the accused, we are saying, we are giving the court an assurance that the accused is going to come back to attend to his trial. So the court can be free to release them because they are committed to come back and attend the trial. So a bail application, very important, ladies and gentlemen. it's always urgent. So when you go to the courts, there are, depending on the area, where you find busy courts that will even have a dedicated court that will deal from 9 to 4 only with bail applications. That is how serious, bail applications are, and how they should be treated. So our law, in terms of Section 60, it's there to give us an opportunity to apply for the bail, and also gives us the different options when we can canvass the issue of bail, because the idea is, remember, the presumption of innocent until proven guilty. No matter how serious the allegations the accused is facing, our goal and our aim is to minimize the impact on the accused freedom at a stage when they have not yet been convicted. So we are still holding on to the hope and the faith that the accused is likely to be found not guilty of the charges that are being made against them. So the general principle is that the accused is entitled to release on bail at any stage before the conviction, at any stage before the court gives its judgment and finds the accused guilty. You can ask for the bail to be granted to the accused, and you simply going to rely on that presumption of innocence until proven guilty. The court should be certified that the interest of justice, permit the release of the accused on bail, right? So please look out for this interest of justice, and I believe that you will hear it favorably and not favorably many times being said to the accused. So it's a term that the courts, when they are making a decision on whether to grant bail or not, they will say the court ruling is that it finds that it is in the interest of justice that bail be granted to the accused. And also when they are denying bail, they will also say it is not in the best interest of justice that bail be granted to the accused. So it's a two-edged sword, so that you will get. And there is no specific definition that is given anywhere to explain what is the best interest of justice. We just have to make it out when the court is giving its reasoning that this is what they mean. Because yes, there's the administration of justice, which must be made sure that justice is served, but there is no way I can point to and say check section so and so, which gives you a definition of what is this interest of justice. Because like I say, it can be used for and it can be used against a person who's applying for bail. So in the matter of Stuttenheim versus Mashia, it's a Supreme Court of Appeal case. The magistrate in that matter was dealing with a bail application, and he had the evidence that was presented before them from both sides of the state and the defense. And then when that was done, the magistrate had postponed the case for 8 days after hearing evidence of a bail application. The defense obviously wanted this matter to be dealt with speedily and decided to appeal, approach the High Court with an appeal for, the decision of that magistrate to be overturned. So an order was sought by the defense to compel, actually, the magistrate, that magistrate should hear arguments and give judgment on the same day that the application was heard. The order was granted as requested by the High Court. However, when they went back to court, the magistrate, after he heard the arguments, he postponed the matter for a further 5 days for judgment. Now, the defense again brought another urgent application, this time before the full bench, for the release of his client on bail, and the magistrate was held to be in contempt of the previous court order for not complying with an earlier order that had directed that he should listen to the arguments and give judgment. And that full bench actually ordered the immediate release of the accused on bail. On that high note, I think we should leave it here because it's enough, ladies and gentlemen. We have questions before we close, or comments that you can preserve for tomorrow with fresh energy. Richard wants to close for us.
Yes, I would, ma'am, I would like to close on the following note. That's-
Are you playing us a song, Richard, or
That's the Deja Vu song.
Oh, okay. I see something going on about it.
Go on.
Richard, we are in class.
That's the way you close down the class.
Okay, let's
Okay. Good night, everyone.
The song goes out there to Elsie. The song goes out there to Elsie.
All right.
Night, everybody.
Bye-bye.
I rest your arms.
Night, bye.
Bye.
Night, guys.
Who's on?
Strawberry ice cream, 1 spoon for 2 and trading jackets, laughing about how small it looks on you. empty rooms of glass. You played a role.